You're at 109 right now.
Ladies and gentlemen, if you're joining me now, I'm Larry Wiggs. This is the IC 109 podcast. I'm going to read from California's Black Pioneers, a brief historical survey by Kenneth G. Good, copyright 1974. I'm now into chapter 4. My favorite chapter because it answered so many questions. It also piqued my curiosity about California in its early days, early stages. The title is Slavery in California, Chapter 4. Let's get into it. During its period of Spanish domination, California, like other areas in the New World under Spanish rule, gave legal sanction to slavery. Introduced to the New World in 1501, the enslavement of blacks rather than Native Americans was given encouragement by Bishop Bartholomew de las Casas. At his urging, Spain issued a proclamation in 1517 setting forth liberal immigration laws for Spaniards wishing to relocate in the New World. As an inducement to colonize, the proclamation allowed each settler to import a dozen black slaves. In colonial days, Buenos Aires and Montevideo became major slave trade centers because they were ports of entry for hundreds of thousands of slaves who were later distributed throughout the Spanish provinces in South and Central America. Rio de la Plata, Chile, the Viceroyalty of Peru, Quito, colonial forerunner of the present Republic of Ecuador, the Viceroyalty of New Granada, which occupied the present territory of Colombia, and the Captaincy General of Venezuela. There were relatively few blacks in Spain, Northern Viceroyalty, Mexico. Let me read that again. There were relatively few blacks in Spain's Northern Viceroyalty, Mexico. A 1793 census indicates that although the city of Veracruz was a major slave port until about 1739, there were less than 6,000 slaves in the estimated total Mexican population of 6.5 million. In the first 2 centuries of the colonial period, however, slaves were considered very important to the Mexican economy, outnumbering whites in Mexico City in the 16th century. The first record appearance, the first recorded experience, the first recorded appearance of slaves in California occurred in 1535 when explorer Cortez outfitted several vessels for the purpose of establishing a colony in Baja California. Included in this party were some 400 Spaniards and 300 black slaves. More than 2 centuries later, in 1771, the burial of a former black slave, Ignacio Ramirez, in the Mission of San Carlos Cemetery in Alta California, marked the first recorded interment of a black in California. Between the time of Cortez's colonization, exploration of Baja California, and the burial of Ignacio Ramirez, black slaves were brought to California in small numbers. It is known that slaves accompanied other Spanish explorers who crossed the Gulf of California into Baja California and edged northward into Alta California. These slaves helped to build ranchos, missions, civic pueblos, and presidios. In the worldwide movement to abolish the institution of slavery and slave trade, many conventions were held, which resulted in treaties between world powers. Under the Treaty of Madrid of 1817, for example, England and Spain agreed to restrict the slave trade to Spanish possessions in the New World that were south of the equator. In addition, The treaty proclaimed that the slave trade would be abolished throughout the entire Spanish Empire in the New World in 1820. However, in spite of the provisions set forth in this and other treaties, the slave trade was merely restricted, not prohibited, and the institution of slavery continued in Spain's New World possessions long after 1820. When Mexico revolted against Spanish rule in 1821, slavery was still legal and remained so until the president of Mexico issued a decree of abolition on September 15th, 1829. Yet this edict, too, proved ineffective in putting an end to slavery in California. American slave masters ignored the presidential mandate and continued to bring slaves into California as they had done in other Mexican territories. When the discovery of gold in 1848, with the discovery of gold in 1848, the number of slaves entering California soared. Slave owners in the South saw a new opportunity to make a profit by working their slaves in the gold fields. By 1852, there were approximately 2,200 blacks in California, with the majority being slaves. On the overland journeys to California, the slaves worked as cooks, barbers, and domestic servants. Some arrived without any hope of obtaining their freedom, but there were many others who believed, based upon oral agreements with their masters, that if they worked in the gold fields a certain number of years and paid a certain sum of money to their masters during that time, they would be set free. Some slaves did earn enough in the gold fields or elsewhere not only to purchase their freedom, but also the freedom of their families. Reverend Darius Stokes, a black preacher, reported that during the early 1850s, blacks in California had sent home about $750,000 to purchase the freedom of members of their families. He stated that some black persons paid as much as $2,000 for the freedom of their immediate families, and that one person purchased 8 of his children for $9,000, the money being earned by doing laundry. Freedom papers setting forth the terms under which a slave's freedom was purchased were issued for each transaction as proof of the black immigrant's status. In the early days of the gold rush, the majority of slaves were involved in mining. However, if slaves failed to find gold, or if the master had arrived in the state with little or no funds, the slaves were often hired out or sold. In some cases, this meant the auctioning of slaves. The following advertisement concerning such an auction appeared in the June 1852 issue of the Democratic State Journal, a Sacramento newspaper. Negro for sale on Saturday the 26th. I will sell at public auction a Negro man, he having agreed to said sale in preference to being sent home. I value him at $300, but if any or all of his abolition brethren wish to show that they have the first honorable principle about them, they can have an opportunity of releasing said Negro from bondage by calling on the subscriber at the Southern House previous to that time and paying $100. I make this great sacrifice in the value of the property to satisfy myself, whether they prefer paying a small sum to release him or play their old game and try to steal him. If not redeemed, the sale will take place in front of the Southern House, 87 J Street, at 10 o'clock of said day. Addressed to families, the advertisement below was printed in the Sacramento Transcript of April 1st, 1850. For sale, a valuable Negro girl, aged 18, bound by indentures for 2 years. Said girl is of amiable disposition, a good washer, ironer, and cook For particulars, apply at the Vanderbilt Hotel of J.R. Harper. Some slaves, such as Elijah Baker, were fortunate enough to strike it rich. Hired out by his master to work in the Downing Ravine mining area, Baker soon discovered a mine abundant in gold. Unaware of this rich find, his master, who had returned to Georgia, asked Elijah to come back to the plantation. While en route, Baker died, leaving his master to enjoy the fruits of his valuable find. An interesting account relates how a slave working alongside his master convinced the latter that they should tear down their cabin because he had dreamed it was resting on top of a rich deposit. Before the cabin was completely razed, gold deposits worth $20,000 had been extracted. Some places were worked entirely by blacks, free and slave. Negro Bar, located on the American River, was settled around 1849 and destroyed a year later when the Virginia Mining Company drained the river bed, making it impossible to continue mining operations. Water was the great sine qua non of the placer miner. Without it, little gold could have been extracted. Although it has been said that blacks were treated fairly on the mining frontier, slave labor in general was not welcome. The white miners felt that mining should be an individual effort and that no one should profit by another's work. As time passed, the hostility of the white miners toward blacks increased. In 1850, an attempt by a Dr. Earl and a Colonel Thorne to work a group of slaves in gold fields located in the Los Angeles area was abruptly halted by a group of white miners who forced them to leave. A similar incident occurred a year earlier when Thomas Jefferson Greene tried to work his slaves at Rose Bar on the Sacramento River. Vigorously protesting the use of slaves and the fact that Greene had not observed the preemption rules governing possession and working of land, the white miners quickly held a public meeting and decided that no black man could own a claim or be permitted to work in the area. Although black miners, free and slave, were welcome at the gambling tables in the mining camps and towns, they were consistently discriminated against in other places of public accommodation. So it was not unusual for a large mining town to have a hotel and restaurant exclusively for blacks and other non-whites. The legendary hospitality of the gold diggers and gold fellowship of the mining camp did not apply to blacks, and certainly not to black slaves. California's admission to the Union as a free state left unclear the status of those slaves who were in the state prior to admission, as well as those who arrived later. Unfortunately, all existing laws, including the California Constitution, failed to provide a definitive answer. Thus, in court, trials involving blacks accused of being fugitive slaves, the outcome depended on the disposition of the individual judges. In cases where the slaves were returned to their masters, the presiding judges cited the Fugitive Slave Law of 1850, which assured the return of runaway slaves. In referring to this law, the judges were anticipating the rationale of the Dred Scott decision. However, in 1852, the California legislature passed a fugitive slave law, which stated that all slaves who had escaped into or were brought to the state prior to its admission into the Union, were fugitives and could be arrested. In addition, the law stated that any person harboring a fugitive slave could be fined up to $1,000 or jailed for a 6-month term. In practice, the state's fugitive slave law allowed slave owners to continue to bring slaves into the state to work them and later to return them to the South. Or if they did not want to bear the expense for the passage, slaves' return passage, the owner was still able to sell them. Affirming the constitutionality of the California Fugitive Slave Law early in October 1852, the court, in the case of Carter Perkins and Robert Perkins, established that by virtue of its police power, the state had the jurisdiction to arrest and restrain fugitive slaves and to remove them from its borders. Brought into California as slaves in 1849, Carter and Robert Perkins and a third slave named Sandy Jones claimed to have entered into an agreement with their master, C.S. Perkins, under which the three would work for a certain period of time, and then be granted their freedom. C.S. Perkins subsequently returned to Mississippi and, in accordance with the agreement, left his three slaves in California as free men. When California's Fugitive Slave Act of 1852 was passed, however, he saw an opportunity to reclaim them as his property. Perkins quickly had an order issued for their arrest with a certificate authorizing him to remove them to Mississippi. Arrested in Placer County, the three accused men appeared before a justice of the peace in Sacramento, where the needed certificate for their removal was issued. But the county court refused to release them, and Perkins quickly appealed to the California Supreme Court, which ordered that the slaves be remanded to their owner. Citing a number of instances to support its decision, the court affirmed that the state had concurrent jurisdiction in slavery legislation through its police powers. The court's opinion of blacks in California was clearly revealed in the following excerpt of the decision. This subject, return of fugitive slaves, as well as the increase of free Negro population, has for some time in the past been a matter of serious consideration with the people of this state in view of the pernicious consequences necessarily resulting from this class of inhabitants, so much so as to become the subject of a message from the executive of the state more than a year and a half ago. Although I have no doubt that the section of the Act now under consideration was originated for the purpose of securing the rights of the master, yet I am satisfied the desire to purge the state of this class of inhabitants, who, in the language of a distinguished jurist, are festering sores upon the body politic, entered largely into the consideration of the legislature in passing this act. In a supporting opinion, it was contended that the temporary residence of slaves in a free territory or state had no effect whatsoever on the legality of a slave's servitude. Furthermore, it was held that since California failed to emancipate slaves at the time of its admission into the Union, the masters of those slaves retained the right to their services. The fact that the state constitution prohibited slavery was not even considered or was dismissed as irrelevant, since the prohibition had never been made a formal matter of legislative enactment. It was highly unpopular to resist application of the Fugitive Slave Law. In 1855, two abolitionists from Alameda County were ridden on a rail, ducked, and generally abused physically for aiding a fugitive slave. The uneven application of the Fugitive Slave Law resulted in a multitude of legally confusing cases. Both free blacks and fugitive slaves were at the mercy of individual jurists until the Archie Lee case was decided. The slave, Archie Lee, was brought to California in 1857 by his master, C.V. Stovall. When his master decided to leave the state, Lee, aided by local free blacks, hid from Stovall. After being apprehended and taken to court, Lee was released on a writ of habeas corpus, the judge holding that Lee could not be considered a fugitive under existing state or federal laws, mainly because Stovall did not qualify as a transient, having opened a Sacramento school and otherwise evidenced his intent to remain in California. But Lee's freedom was short lived. He was immediately rejailed, pending an appeal to the California Supreme Court. Speaking through Chief Justice P.H. Burnett, a former state governor whose racist attitude toward blacks was well known, the court, while admitting that Lee had a legal basis for his freedom, held that it would suspend its own rules so that Stovall could take Lee back into slavery. The court was widely criticized for its hypocritical decision, which soon became a major topic of discussion throughout the state and nation. The case did not end there, however. While passing through San Francisco on his way out of the state, Lee was set free by a group of sympathetic blacks and whites who had obtained a warrant charging Stovall with kidnapping and a writ of habeas corpus authorizing Lee's apprehension. Finally brought before a U.S. commissioner in San Francisco, Lee was set free on grounds that he was not a fugitive slave. His master had voluntarily brought Lee to California, intending to become a permanent resident of the state. This, together with other facts in the case, was sufficient to release Lee. The state fugitive slave law, although on the books only a few years, was intended to frighten blacks into leaving the state, and it succeeded to a limited extent, for some blacks did migrate to Canada, Mexico, Baja California, and Central America. When the Archie Lee case came to public attention, blacks throughout the state recognized that the right of black people to live in California would be directly affected by the trial's outcome. Many came to his defense, both as individuals and in groups, such as the Executive Committee of the Convention of Colored Citizens of the State of California. Prominent San Francisco blacks, Mamie Pleasant and George Washington Dennis, among others, helped this committee to raise more than $50,000 for Lee's legal fees and other expenses. All over the state, black people mortgaged their homes, gave benefits, begged and borrowed to help Lee. When Lee was finally released, racial tension in San Francisco was so high that Mamie Pleasant hid him in her home until the executive committee could secure his safe passage to Canada. Sometime later, Lee returned to the Sacramento area where he resided until his death. After the Lee case, which was the last to be tried under Fugitive Slave Act of 1852, black people were less apprehensive about appearing in court on similar charges. However, even with the Emancipation Proclamation in 1863, it was not until 1865 when the 13th Amendment to the United States Constitution abolished slavery nationwide that California's black population really began to think of themselves as free citizens. Interestingly enough, the Emancipation Proclamation was of little consequence to blacks in California because it freed only slaves in states which were in rebellion against the Union. California was not. Was that actually my favorite chapter? No, I don't think it was my favorite chapter, although it gives a lot of information about slavery in California, fugitive slave law, what with all the fugitive slave law and other things. I think it's Free Blacks. Free Blacks in California, the next chapter, chapter 5, that is really that pièce de résistance. You're listening to IC 109 reading California's Black Pioneers, a brief historical survey by Kenneth G. Good. Copyright 1974. Peace and blessings from IC 109. I'm out.
You're at 109 right now.